Five pillars of the Philippine criminal justice system. Number 1. Law enforcement and police. First, a contact of offender says they investigate wrongdoing and makes arrests. 2. Prosecution proves the guilt or innocence of wrongdoers. 3. Court venue where disputes are settled and justice is administered. 4. Correction after accused is found guilty, he is put to jail or reason to be reformed. 5. Community where the convict after service of sentence comes back to be integrated to be a productive member of society. Number 6. Legislative law enforcement. Create and administered laws. 7. Courts. Add education. 8. Corrections. Heal. Prison. Provision. Parole. 2. Classification of criminal law. Substantive. 9. Defines the elements that are necessary for an act to constitute harm, therefore punishable. 10. Refers to a statute to provide procedure are appropriate for the enforcement of substantive criminal law. 11. In criminal since a person may be considered as a criminal from time he or she commit the crime, regardless whether or not it has been recorded to the police for investigation. 12. In legal sense, a person may be considered a criminal only upon undergoing the judicial process and upon the determination by the court that he or she is guilty beyond reasonable doubt. 13. Criminal justice system. A criminal may be defined as one who has undergone a process or went through or the pillars of the criminal justice system. 14. Of the police states during the investigation, he is referred to as suspect. Respondent. The preliminary investigation, he is referred to as the respondent. 16. At the trial of the case, when a case has been filed in court, he is referred to as the accused. 17. Once the court has determined that the accused is guilty beyond reasonable doubt as charged and the judgment has been rendered, he is referred to as the convict. 19. The absolute ability to identify the law violator. The absolute ability to apprehend law violator. 21. The absolute ability to punish law violator. 22. The absolute ability to identify the intent the law violator. 23. The innocent is punished. 24. The guilty is punishment. 25. The guilty are punished more severely than necessary. 26. The guilty are punished less severely than necessary. 27. The five pillars of the Philippine criminal justice system. 27. Law enforcement. 28. Prosecutor. 29. Courts. 30. Correction. 31. Community. The three components of the criminal justice system in the United States. 31. 32. Law enforcement. 33. Courts. 34. Correction. 35. The general functions of the law enforcement in relation to the administration of to the CJS. 35. To prevent criminal behavior. 36. To reduce. 37. To apprehend, to arrest offender. 38. To protect the life and property. 39. To regulate the criminal conduct. 40. Pertinent laws of PNP. 40. RA 9675 DILG of 1990 approved on December 30, 1990. 41. RA 8551 PNP Reform to Organization Act to 1998. 42. RA 9708, an act extending for 5 years the agreementary period for the complying the minimum educational qualification for appointment to the PNP. 43. Function of the NBI. Investigate crime and the offenses against the laws of the Philippines, both in its own legislative. 44. Assist on officially request investigation or addiction crimes set. 45. Act as national clearing of as a criminal reverse. Give technical law enforcement offenses agencies of the government. 47. Extended and services on the investigation cases of the administrative. 48. Establish and maintain an act to the scientific crime laboratory. 49. To coordinate to other national or locally agencies and maintenance of order. 50. Other takes the instruction and training of representative police roles and function in society. Basically role and the police in society and prevention which to the bingo of the agencies. Crime the detection in relation to the administrator of through crime detection, the police, and typically the first component to the justice system to deal with the commission to the crime. 53. Importance of arrest and the administration CJS. Arrest is important on the administration of criminal justice system because if accused is not arrested. 54. Probable cause and effective arrest. Probable cause and with respect to arrest is such the fact and circumstances with reasonably discreet. 55. Search warrant. It is an order writing issued in the name of the people of the Philippines signed by the judge and connected to the peace officer. 56. quitties is once for the warrant of arrest. The search of warrant shall issued only upon 57. Personal property to peace seized 57. Subject of the offense 58. Stolen or investigated or other process proceeds fruits of the offense 59. Used in or intended to abuse commission of the offense 60. Some of the example of police discretion 60. Whether or not to enforce to the specific law 61. Whether or not to the conduct of the people 62. Whether or not to determine kinds what kind to be filled 64. In Philippine CGS or conduct the prosecutor. In the Philippines, the prosecution or a prosecutor is government officer. Thus, to conduct the prosecution of the criminal function or court. 65. National Prosecutor Service or the PNP. The PNP under the supervision to control the Department of Justice or DOJ is the prosecutorial arm of the government. Some role of the prosecutor 66. To conduct preliminary investigation 67. To make the proper recommendation into the quiz to refer to by the police the 68. To represent the government by the prosecution in case in judge status 69. To conduct to legal the province of the city in the obstance of each legal officer 70. To investigate administrative cases, field agents, state prosecutor, provincial, including the support staff of the National Prosecution Service 71. To determine legal crime has been to commit whether there is probable cause to believe that the accused is guilty thereof. 72. Prosecute the innocent has malicious and appropriate prosecutor. 73. To protect the state from useless and expensive trials. Persons authorized to conduct preliminary investigation 74. Provincial of city prosecutor and under the assistant 75. Judge of the municipal trial court and municipal circuit trial court 76. National and regional state prosecutors 77. Others officer as may be authorized by law. Others officers authorized by law to conduct preliminary investigation 78. The Ombudsman and Special Prosecutor, a prosecutor duly authorized by the Ombudsman with respect to cases under jurisdiction 79. The Comelec with respect to cases in violation the election law 80. Private lawyers when duly deputized by any of above. Prosecutor's discretion 81. Whether or not to file the case or court 82. What charge to file 83. Whether or not to decline to prosecutor the arrest party. 84. Whether or not to enter to play bargaining. Insufficient evidence that result from the field to farm sufficient physical evidence to clean the defendant to the offense. 86. Witness problem that the arrest, for example, within witness failed to appear gives or a clear and consistent statement is reluctant to testify is unsure to identity of the offender. 87. Due process problem that involves the violation of the constitutional requirements for seizing evidence and for the questionnaire of accused. 88. Trial the motion or the consideration. 89. File an administrative case against the prosecutor. 90. File the civil case against the prosecutor. 91. File the criminal case against the prosecutor. 92. Jurisdiction. It is the authority of the court to hear the trial. A particular offense to the punishment provided law. 93. Venue refers to the place, location, or society or the case to be heard its merits. 94. Court of Appeals. Appellate jurisdiction, decision, or judgment of the Supreme Court. Appeal jurisdiction, decision, or judgment of the CAN Sandigang Bayan. Court exercise description. 96. To set bail to condition for the release accused. 97. To rule on the procedural matters as raised by the defendant or the prosecutor during the trial. 98. To impose or not. 99. To convict or acquit the accused. Last 100. To revoke provision or suspended sentence.